All right. So we're going to move into racial desegregation in other areas today. So we're going to leave behind uh, schools for a tiny bit. We're actually going to come back to them at the end. But we're going to sort of hit a couple other things. And the first thing we're going to talk about is racial desegregation in terms of housing and look at the case Shelley v. Kraemer. So it's important to know that in housing areas, housing as it moved forward was a method by which to sort of help enforce school desegregation or help enforce school segregation efforts. So when new laws in various areas started to crop up, they turned out to be much more successful here than actual legal prohibitions, because if you would allow African Americans and other racial minorities to buy and own homes within traditionally white school districts, it was obviously very difficult to keep them from going to those schools based on the decision in Brown and the desegregation efforts going forward. There didn't exist a lot, or should I say, there existed no national laws until 1968 with the Fair Housing Act. But a lot of these laws were taken out through the state levels and through local levels. And so what the Fair Housing Act of 1968 said is that it sort of reinforced the idea that the Civil Rights Act of 1866 already prohibited discrimination in terms of housing. If you remember the Civil Rights Act of 1866, it actually had difficulty reaching businesses, if you recall, but it actually had no problem with reaching housing because housing by its kind of nature is an interstate commerce sort of thing. Plus, the court also says you shouldn't put the rights of minorities up to public referendum. This was one of those things where I remember quite distinctly where Ireland passed a gay marriage law and allowed gay marriage. Ireland being notoriously extreme, very Catholic nation, and one of the main commentaries going around about it is we really shouldn't put the rights of a majority or of a minority group up to majority vote, because that's tendally a bad idea because minority groups don't typically get protection through majoritarian efforts. So one of these things is these laws have had limited success because they're pretty difficult to enforce. If a private actor chooses not to sell a house to another private actor that happens to be of a minority group, it's pretty difficult to actually enforce those sorts of laws. But the courts have put up some sort of bulwarks that actually help protect them in that regard. And one of them actually happens pretty early on in Shelley v. Kraemer. So Shelley v. Kraemer is actually a pretty straightforward case, I think. It comes out of St. Louis, and there existed in St. Louis in this community where this house was sold. So the case arises like this. An African American family purchases a house in an area in St. Louis, but this house in this area where they were living was subjected to what is known as a selective covenant or a restrictive covenant. And the restrictive covenant simply read that people of the Negro or Mongoloid race should be prohibited from occupying the property. And therefore, other individuals within the neighbor who were also subject to this selective covenant challenged this African American family buying a house there, and it was ultimately blocked. And so the effort of the selective covenant was enforced by the Supreme Court of Missouri, and that's how we get this case. The case from the Supreme Court of Missouri is appealed to the court. So you probably noticed that while this is a unanimous case, it is not a 9-0 unanimous case. Justices Reed, Jackson, and Rutledge did not participate in the outcome of this case. And the reason for that is that Justices Reed, Jackson, and Rutledge all owned properties that were subject to selective covenants. So they simply did not participate in the case because they had an interest in the material outcome. So it's a unanimous case, it's a 6-0 case, but it is not a 9-0 case because there were obviously issues involved with those three justices who didn't participate. So the individual who actually challenges the Shelleys buying this home is an individual who lived kid you not, 10 blocks away from where the actual home was. I don't know about you, but I don't know anyone who lives a block away from me, let alone 10 blocks away from me. So this was not only an active racist, this was a very diligent racist in regards to his own attempts at enforcement. So there are a couple issues in this case, but the one that we're primarily interested in is whether courts can enforce these selective covenants. And so the question is, first off, are these racially restrictive covenants a violation of the 14th Amendment? And then second, can they be enforced through the judicial system as a court of, or through simply a court of law? And so Chief Justice Vinson writes the majority opinion and states very clearly that private actors can absolutely abide by these selective covenants. So if you entered into a selective covenant and you wish to sell your home, you can individualized enforce that selective covenant and simply refuse to sell to African Americans or individuals of any other race. Like that transaction between private actors, the 14th Amendment doesn't reach that, at least in 1948. But Justice Vinson comes back and says, however, those selective covenants absolutely cannot be enforced in courts of law because it is the state, i.e. the state of Missouri, or even the state, i.e. the United States, so different country arrangements, the state simply would be violating the 14th Amendment by putting its enforcement behind the selective covenant. So if the states endorse or choose to enforce these selective covenants through the judicial system, then that act violates the 14th Amendment Equal Protection Clause, because we find that individuals of one race are being subjected to different legal enforcement than individuals of a different race. And so this case basically took away the ability of these selective covenants to be enforced judicially. This doesn't mean that selective covenants went away. In fact, there was a case just a few, honestly, I think about 2 or 3 months ago, about a family who had bought a home in California, a Hispanic family that bought a home in California and found out through a record search that their house was subject to a selective covenant, that the seller simply probably didn't know about it or chose not to enforce it, but technically that house as it existed was supposedly under the control of a selective covenant. So this is something that lingered on. It's not like 1948 ended this practice. What it did end is the practice of courts actually enforcing these individualized contracts between peoples. So after 1948, it became significantly more difficult to enforce these selective covenants in any fashion outside of private actors simply doing it on their behalf. But it removed the ability of an individual like Kraemer in this case to sue that the seller of the house violated the selective covenant by selling it to an African American family.